Hello, and welcome to Healthcare Matters, where the medical and legal communities come together to discuss healthcare matters. I'm your host, Mike Matray, and today's guest is Troy Bundy. Mr. Bundy is a hiring partner at Hart & Wagner in Portland, Oregon, where he has been defending healthcare professionals since he joined the firm in 1996. Welcome to the show, Troy.
Thanks, good to be here.
A relatively recent phenomenon in healthcare delivery has been the expanding availability of healthcare services in America's big box retail stores. CVS recently purchased Target's in-store health clinics, making it the largest retail healthcare clinic chain. How do liability risks differ in these big box retailers as opposed to a doctor's office? And how would you recommend these new healthcare delivery sites mitigate their risks?
Well, as far as an evaluation of how the risks differ, I would have to say that there's no difference in a big box retailer clinic as opposed to a regular standalone clinic as far as the standard of care is concerned. So the reality is there are not differing standards of care for a clinic versus a standalone clinic versus one that's in one of these retailers. The risks are that the staff will pretend as though the standard of care is different. But I think in reality, I've personally never seen that occur. I myself have gone to an ophthalmologist, for instance, as in Costco, and I use him. Examinations are the same, everything's the same, but I think that there could be a potential risk that the services are not treated as though they are within a standalone clinic. The reality is you need to, if you are operating a standalone clinic, you need to follow protocol, appropriate charting, EMR, and refer patients when you need to. If there's any suggestion that a referral is indicated, it needs to occur. The other risk is, I think, from a patient perspective, they may or may not treat the visit as though they were going to a formal physician's office or clinic setting. And so it's going to be important for the clinician to, probably dig a little bit deeper in determining what problems or complaints the patient has that's bringing them to the clinic that particular day.
All right. Well, one of the major differences is I too have been to a retail health clinic, and it was a nurse practitioner, a physician's assistant, and there was no actual MD or OD on site. And one of the things I noticed would be that what if a more pressing health matter is discovered in the retail clinic? How would they note in the electronic health record or the traditional medical record that they referred the patient to an actual MD or a cardiologist? And how would that stand up in court?
Well, I think in any clinic setting, you're going to run into, especially urgent care, you're going to have physician's assistants that provide some of the care, or perhaps nurse practitioners. And the reality is, when it comes down to litigation, a PA, though we'd like to just say, well, the PA met the standard of care as it refers to other PAs in the community, that's usually not how it goes. The PA is going to be doing work that a licensed MD will perform, and therefore I think that most juries are going to hold the PA to the higher standard that's required. So routinely I will, in my cases where I'm defending PAs or NPs, my standard experts are going to be internists or family practitioners, whatever the case may be, or emergency room physicians, because I think that is really the standard that's being employed, despite the jury instruction that it's supposed to be the same medical specialty with like training and experience. So, as far as referrals, they need to be well documented in the chart, and that's really all that the referring clinician can do, is make sure that the referral documentation is well set out, both in the order and the progress note, and then most of the time there's going to be a patient take-home of some kind that will have instructions. They usually say something along the lines of, I've recommended that you see a urologist for this problem, or I've recommended that you follow up with your regular primary care provider in regard to your sugars, or whatever the case may be. But I think documentation is always the linchpin of any medical malpractice case, at least.
In your professional experience, do higher limits on a physician's medical malpractice insurance increase the dollar value of settlements in cases of an indefensible claim? In other words, can a physician or entity be overinsured? And conversely, can a case be made that the lower the limit, the lower the risk exposure?
Yeah, I've dealt with that issue recently, and I understand the thought process of wanting to potentially lower exposure by lowering limits, but I don't agree with it. I think it's a dangerous practice, to be honest with you, and you better make sure that there is no ability to pierce the veil and go after personal assets, because it's, in some instances you may have a situation where you only carry, for instance, $1 million in coverage, but yet you're dealing with high-risk patients, and you don't want to get that extra umbrella, or you don't want to go to a 3-5 policy or something like that. I don't think it has any impact, to be honest with you, whether or not you have less limits available to a plaintiff's attorney. In some instances, and this is one of the points that I discussed with some of my clients, you may have a defensible case, but the exposure is high and well above limits, so there's more of a likelihood that you would settle a defensible case because of the excess exposure issue, which then can result in additional premiums having been paid because you've been settling cases. So I do think, to a certain degree, the nature of the practice is important to consider. If you're running an OB clinic, if you are taking care of high-risk pregnancies versus a standalone primary care clinic, there may be something to it. But there's no universal answer, and I liken it to yeah, you can ride your motorcycle without a helmet, but if you get in a wreck, you might want to have the helmet on. And quite frankly, I haven't seen any evidence to suggest that because there are lower limits, you're less likely to be sued, or you're less likely to get out of a lawsuit. Quite to the contrary, if you have lower limits, it's just like anything else. If you have a high dollar value case, and the risk, and when we evaluate a lawsuit, we're always asked about defensibility. It's never about, well, what about the fact that there are no, very little limits? When there are very little limits, it raises a number of issues. And let's talk about, for instance, the clinic that decides to carry a $1 million limit policy, but yet routinely sees lawsuits that are brought against it far in excess of $1 million. The assets of the clinic are still at risk. Just because you only have $1 million in coverage, that doesn't mean that the clinic is safe and it only has $1 million worth of exposure. The assets of the clinic can be leaned against. The assets of the clinic can be collected, and the clinic can be closed as a result of a loss because you were underinsured, or any number of things. But the fact is, if you have a corporate structure, a clinic that you're trying to protect, you want to make sure it's adequately protected, and carrying limits that aren't enough or that are very low to dissuade lawyers from suing you is not going to work. There's always a lawyer out there who is willing to sue and collect money. So my advice is always to make sure you have plenty of insurance. And in the event that we have a catastrophic loss or a big problem with a lawsuit that necessitates a big payout, we'll have that money available. Because the fact is, most lawsuits, if you have a $1 million with a $3 million umbrella, or a $3 million with a $5 million umbrella, or whatever the case may be, if you have enough adequate coverage, then we will be able to either defend the case 100% to its conclusion if it's a defensible case, or we'll be able to negotiate a settlement well within the policy limits so that you can keep your corporation and keep your clinic active. But leaving yourself out to dry in hopes that, they won't chase after me because I don't have a lot of insurance, it's not a well thought out, in my view, business plan.
One of the hottest trends employed by the plaintiffs' bar in medical liability lawsuits recently has been the Reptilian Theory. Can you explain the concept of the Reptilian Theory, how it influences juries, and how the defense counsel can diffuse this strategy?
Yeah, the Reptilian Theory pokes its head in from time to time into my trials and into the discovery process. But basically, as I understand it, and I've read through there's a couple books out on it, but one in particular called Reptile, which I've read over just so I can stay on top of their game. But the idea is that, in a nutshell, you want, if you're the plaintiff, to talk about safety and protecting the public and making sure that procedures are safe and standards of care exist as a safety measure. And so during the course of discovery, you might hear questions in a deposition like, well, is this safe practice? Or you do that because it's the safe way to do it, right, doctor? And that kind of stuff comes in all of the time. But, safety is not synonymous with the standard of care. And that's the fallacy. So the story that the plaintiff's attorneys that use this strategy are trying to sell is that, hey, this is all just about safety, and this doctor was unsafe, and therefore, they should have to pay a lot of money. And they're appealing to this reptile part of the brain that they call, which is that jurors are ultimately self-interested and want to protect themselves and their families and their loved ones from events like this occurring to them or others in the future. And so that's basically, the theory behind it. And my experience with it is that it doesn't really work, at least in our setting. The objections that I raise during trial are typically, I object, that's not the standard of proof. Safety is irrelevant. And most of my witnesses are prepped to deal with the safety type questions. And the prep I typically discuss with the expert, if it's appropriate, is, medicine itself, a surgery, for instance, is not safe. Nothing is safe as the jury wants to hear it is. There are risks and there are degrees of risk to every type of procedure that a patient can undergo. Some things have a higher risk than others. But ultimately it boils down to surgical judgment or physician judgment, depending upon the procedure that we're talking about. And so I think that the best approach, at least the one that's worked the best for me, is to kind of turn the argument on its head and say, have the response be, well, your use of the word safe is confusing to me. And it implies that doing it another way is unsafe. Here's the deal. As a physician, there are degrees of risk, and some risks are worth taking and others are not. Some risks or some procedures are very risky, but there's no other option. Some procedures, there are different ways to do it. They both have different kinds of risk. Each one is extreme. So I think breaking down the question into terms of risk rather than safety, because safety really isn't a fair question to ask about, especially when you're talking about a medical setting. It allows the physician to answer the question fairly, which is really what it's about. But most of the time, I've seen the plaintiff's lawyers dabble in this idea using the reptile strategy, as they call it, but they usually abandon it after a few objections are sustained. And if the objections aren't sustained, then I will attack the theory head on with my cross-examination, or usually my redirect examination of my own witness, because it usually comes out in cross-examination, and I'll just say, there was all this talk about safety this, safety that. When someone asks you, is this procedure safe? If a patient were to ask you that, for instance, what would your response be? And that kind of gives them the ability to start talking about, hey, there are no guarantees in medicine, which is typically a standard jury instruction. We don't, guarantee a cure, and we are invading your body when we're performing surgery, or something significant is happening to your body that we are trying to deal with, whether it be a birth or some other procedure like that. So it's all about explaining to the jury that this isn't all fun and games. There's always risk. There's a risk in getting a tetanus shot. You can get an infection. You can have a number of things occur as a result of that. You can develop an abscess. And so no matter how small a procedure, there's always a risk that you cannot completely eliminate.
So it's basically you're trying to redirect the jury's attention to the fact that the standard of care is the question in front of them. You were involved in a significant case in Oregon, which involved shoulder dystocia. Could you tell us about that case and what made it significant and how it played out?
Yeah, it was a case actually that I lost, and the case played out typically as a shoulder dystocia case does, which is a patient went in and delivered a baby. The baby was large, and the allegation was that there was a shoulder dystocia encountered, which there was. Maneuvers were employed in order to relieve pressure from the shoulder and prevent the typical injury, which is a brachial nerve palsy or brachial plexus injury. And the baby ended up with residual problems with his shoulder and arm. And I've tried a number of those cases. What was unique about this particular case was the fact that the mother had experienced a prior shoulder dystocia, and that she didn't know that she had a prior shoulder dystocia.
How did you discover that she had a prior shoulder dystocia?
Well, the whole crux of the case was the fact that the documentation of the shoulder dystocia was in the delivery report or the delivery record, and the delivery record was part of the clinic file. But the way the clinic worked was, people have more than one child over the years, and rather than carry forward the entire chart, which was essentially converted to an EMR, a new mini chart would be created for the patient for the new pregnancy, so that there wouldn't be, a large chart to deal with all the time. So the information was there, and I saw it in the medical records, as did the plaintiff's attorney. But the doctor didn't review all of the medical records. And when the nurse asked the patient if she had any prior complications associated with previous pregnancies, the mother responded no. And so the case was managed as though there was no prior shoulder dystocia. What was interesting was that the physician who charted a shoulder dystocia charted a lot of shoulder dystocias. He encountered an extraordinary number of shoulder dystocias in the course of his practice. And so what we were dealing with was what the literature routinely refers to as an overcall. This is, whether or not a shoulder dystocia really occurs is ultimately something that the physician determines at the time of the birth. Obviously, there's going to be times when, that's a shoulder dystocia. But there are going to be more subtler forms that most obstetricians will not refer to as a shoulder dystocia. They just won't call it that. And that's really what this was a judgment call that one physician made. The downside of the case was that it was well documented in the chart. It ultimately proved to be too much to overcome. But the thing that I learned in that case was that this trial tactic, it seems obvious now that I've had it occur to me. But one of the things that the plaintiff's attorney did was he moved to admit the medical records that had been prepared and submitted to my expert for review. And those records were really no different than any of the other records that we had admitted in the case. We didn't object to the admission of our expert's file, essentially, or a portion of the file to be admitted into evidence. So that was in, and nothing really occurred with it, and the plaintiff's attorney didn't say anything about it until closing argument. And then all of a sudden, in closing argument, the plaintiff's attorney referred to an ICD-9 code that said shoulder dystocia and made an argument that the words shoulder dystocia were included in the file materials that we had, and our provider knew about it, and that we were somehow hiding the ball, and so on and so forth. But the lesson I learned was that whenever we agree to admit an exhibit, even if you don't talk about the exhibit during the course of the trial, it's open season and fair game for closing argument. And you can make whatever argument you want, however far-fetched an argument the plaintiff wants to make about whatever piece of evidence has been admitted is fair game. And that left us with trying to respond and explain to the jury, which was basically impossible because evidence had concluded that, hey, this is an ICD-9 code. That is something a coder came up with. That is not part or seen in the EMR when our physician was looking at the chart. So the lesson I learned was be very, very careful what you agree to as far as the admission of evidence. And just because something is not discussed during the course of trial and doesn't come up during the course of trial, that doesn't preclude the plaintiff, or if the defense wants to use it, the defense, from making an argument to the jury at the end of trial that the other side can't respond to or legitimately respond to. And so I learned my lesson during that trial about the power of an admission of evidence, and whether somebody can create an issue that never existed throughout the course of trial by raising it at the last minute during closing argument.
Without an opportunity to respond.
With no opportunity to respond, right.
Well, Troy, I'd like to thank you for coming on Healthcare Matters today. It was wonderful to have you as a guest, and I hope you'll come on again soon.
Thanks.